has undergone some flux. It was initially just titled something non-creative like ANDA litigation, and then we've kind of played around with it. And obviously, we're going to talk about ANDA a lot, and that will be the focus, by and large, of the conference or of the panel rather. But it may get a little bit broader at times because really ANDA is one of the competitor situation, really the biggest one probably facing most pharmaceutical companies. But what I want to do before we get started, before I get too far down the road, is at least briefly introduce, Phil Johnson, chair of the 21C Group, former chief patent counsel, chief IP counsel at Johnson & Johnson. We introduced him yesterday. We just introduced Brianna. And the new member of the panel here is Blake Koblenz, and he is chair of the Hatch-Waxman and Biologics Litigation practice for Cozen O'Connor, and he focuses his practice on patent litigation and counseling clients in the biotechnology and pharmaceutical industries. So the reason why we broadened it a little bit beyond just ANDA is to capture that biologics aspect as well, which we've spent quite a bit of time talking about, at least in terms of the IRA and likely moving from small molecule to large molecule incentives and that sort of thing. So biologics litigation is probably only going to grow in more importance as we move forward. But I'm not the expert, so let's hear what you all have to say. Blake, why don't we start with you and ask, just generally speaking, before we dive into the topics here, what do you want people to think about or to prime the well on this topic, competitor on competitor in the biopharma space?
Well, yeah, thank you, Gene, and thank you for inviting me to speak. As we're getting more and more into these biologics v. biosimilar litigations, and we're starting to see records develop and starting to see more of these products being challenged, we start to see the investment that that the biologics have made, but also that these biosimilar companies have also made in developing these products. And it's different than the Hatch-Waxman world because they've spent a lot more money. These biosimilar applicants have spent a lot more money developing these products, and so it's a very different aspect of when you're a biosimilar applicant and you're developing these products. When you're in the Hatch-Waxman world, I tell generics a lot, you can kind of wait a little while. You need to kind of look at the patents on the Orange Book and look at them and determine your positions. But when you're in a biosimilar world, you don't have that Orange Book. You need to do your homework years in advance. And that's a big difference for biosimilar applicants than Hatch-Waxman applicants because they don't have a Orange Book to look at, so they need to do the initial freedom to operate work well in advance of their development, which is a big difference here, and it is a more costly thing for those applicants than it would be for the Hatch-Waxman side. So it's important to understand that, but it's also important to understand that unlike Hatch-Waxman cases, process patents in the biopharma world are fair game, and we see those patents asserted a lot. The biosimilar case, the first biosimilar case that I did, the sole dispute was over a process patent, over a extremely old protein, pegfilgrastim. The sequence patents had, long expired. But Amgen, sued our client, Apotex, on a, protein refolding patent. We went all the way to trial on that case. So that's one of those patents that you don't think about in the Hatch-Waxman world, but you have to constantly be thinking about when you're looking at the biopharma world.
Okay, great. Thanks a lot, Blake. Phil, your preliminary thoughts on this topic?
Well, I think that the biosimilar situation is indeed markedly different than you're dealing with. I mean, first of all, in this entire space, it's unusual in the filing and prosecution because that essentially every patent that you get is going to be subject to litigation. At least the odds of them being subject to litigation, if the product itself is successful, are much, much higher than you would have anywhere else in any other technology. And so I wholeheartedly endorse the suggestions that were brought up in the prior panel that you should have litigators involved from early and often. And I think the best practice in most pharmaceutical companies is to simply schedule that. We used to call them stage gate reviews. I think that's the most common thing. And you would have, reviews from the time of allowance and periodically to take into account developments in the law, foreign prosecutions. Of course, a lot of them are subject to continuations, and you want to be sure you get all the foreign cited art in front of the U.S. Patent Office, and you basically are trying to build a gold-plated patent every time you have an important drug under development. And so that changes things. But biosimilars change things too, because there's, depending on the nature of the compound, a company can choose to develop a biosimilar or can choose to develop a biologic that happens to be similar. It may target the same receptor. And there are advantages to that and disadvantages to that. But when you get into the true biosimilar, you have a different kind of marketplace when the biosimilar is eventually introduced than you do with Hatch-Waxman. With Hatch-Waxman, the state substitution laws and otherwise substitute the generics. The price falls very dramatically because the generic hasn't had to put much money in to develop the generic to begin with. And there's a lot of competition, often all at once, because of the rule that everyone who files on NCE1 the first day you can file will share the 180-day exclusivity, which means essentially nobody has the 180-day exclusivity anymore. So you have a very different kind of marketplace because you don't see the same thing with biosimilars. And then you have more reluctance on part of the prescribing community to necessarily substitute a biosimilar, because if a physician's had a patient on a biologic and the patient is doing well, and biologics are more likely, of course, to have immune reactions based on changes you can't predict. A lot of physicians are a little skeptical about switching over to a biosimilar. And of course, the patent owner has the opportunity to reduce price, which a number of them will do in order to delay market share being built too much by a biosimilar. So it's a very different kind of landscape.
Yeah. So how many companies in the life sciences area do you suppose are seeking out litigators on any kind of regular basis to get input? Is it widespread?
Every sophisticated
Well, see, and that's what I'm trying to get at, right?
competitor.
Like the sophisticated companies do it, right?
I mean,
so
these are competitors. They don't call us up and say, hey, guess what? We're bringing in our outside counsel to do an internal review. You don't have any.
right.
But I can tell you from having been president of Interpat that these are the standard best practices that I think all reasonably active companies do to some degree or other.
Right. So that's what I'm trying to get at. So if you are in this space and you are not doing this, you need to realize you are in the minority and you're not engaging in best practices.
I mean, many of these compounds may be started by companies, small companies, that end up being acquired by people who will take them the distance. And one of the problems with the acquisition is these small companies often don't have the counsel who are sophisticated both in-house
Right.
and perhaps outside, or didn't have the money to do what you wish they do. And so part of the development process, because you usually have time, is to get your people in and go over the portfolio and see
And that's a part of the diligence
see
process.
what else
Right?
needs to be done.
Okay. And that's what I was trying to get at. So if you are a smaller company and you're not doing this, and you have ideas that you might be a acquisition target, you're not necessarily doing yourself any favors, because you're not going to be able to avoid it. It's going to come up during diligence. This is the best practice. You should try to the greatest extent that you possibly can to be doing this, because the serious players are doing it. I see you shaking your head, Brianna.
I completely agree, and I'm just thinking, you can do it on different scales, right? You're the smaller company, you don't have as much funding at this point in time. As we talked about in our panel this morning, not every assessment has to be a full-blown war games assessment, right? You don't have to put millions of dollars into a mock trial running every possible argument. It really can be just litigators pressure testing things, kind of coming in with their experience, looking at the record, and having those conversations. If you are on the eve of a bet the company litigation, at that point you do want to, consider that big war game. But just having us in the room so that we can advise isn't, going to kill the budget, but it is going to pay off, dividends in the long run.
Right. Okay.
I
Blake, you
think
wanna follow up?
from the biosimilar applicant side, I see more times than not biosimilar applicants are engaging outside counsel early on, large and small, because they understand that the significant investment that they are making to make that product, they need to have the comfort, the clearance. It can be, hey, I have these different formulations, do a clearance on that. I'm going to use these upstream, downstream processes. Let's look at that. Every stage of the game, we're seeing the applicants come to their counsel and say, hey, look, am I free to operate? What's my best chance to get on earlier? What patents go out in the 2030s? What expire in the late 2020s? Where can I get the competitive advantage? And that's very different than the Hatch-Waxman side, because a lot of the Hatch-Waxman side, you find the in-houses are looking at the Orange Book patents themselves, kind of advising their people on, hey, this is what I'm going to do. But that's not available for biosimilar applicants, and they don't have the resources to go out and say, what is the portfolio that these companies have? Take the Humira example. If you were relying on an in-house counsel to look at the entire Humira thicket of patents out there, that's a job for about 10 in-house attorneys to try to get done. So, you can look at that and say, hey, look, these portfolios are really, really big, and it takes it takes time to understand what these are and what they cover.
Okay, yeah, I think that is a good warm-up for the type of thing that we want to be talking about. And if there's any questions in the audience, please just raise your hand. The panel will see you, and we can try and address as many questions as you have, because we have a lot of, to some extent, they're discrete. There's probably some overlapping topics that we wanted to cover. One of the first ones is the effect of in-ray Cellect on the Hatch-Waxman industry. But if I recall, that was one that you wanted to get added to the list. Am I right?
Well, it is, because, and I'm not going to sit here and talk about whether it's right or wrong, but I want to tell you that it actually is a big player in the Hatch-Waxman field, and we just saw a case that came out from Judge Andrews about 3 weeks ago, which applied in-ray Cellect, and actually there was an obviousness type double patenting rejection that Andrews came forward and said, look, this patent's going down because of ODP. I have to abide by what the Fed Circuit has told me in in-ray Cellect. And the patent went down for obviousness type double patenting. And what we see, if you go to the FDA website and you look at the new chemical entity, all the cases coming up, you look at those molecules and you look at the Orange Book listed patents, you'll see that a lot of these patents have compound patents that have multiple patents with the same expiration date, or one that has PTA that's a little longer than a family member. And so there's quite a few of these molecules from the past and in the future, that are coming up that have this issue going. And so, whether the brand company pursued a species claim and then filed a continuation and decided just to get a genus claim, and that species patent got PTA, I mean, there's a real concern there that, if terminal disclaimers weren't filed, that those patents, could go down for ODP, or you could lose that PTA and it gets knocked back down to, to what one of the later patents that issued. So there's definitely a strategy point for big pharma these days after this decision on how to pursue these patents, but it's hard to go back and fix the ones that are already existing out there right now. And as the Judge Andrews case, and for those in the audience that want to know, it's an Allergan v. Sun and MSN case that came out late September. Go read that. It's a short decision on the obviousness type double patenting, but he applied it in about a page and a half and found that one of the patents invalid for obviousness type double patenting.
And just to pick up on that, Blake, to our earlier theme of early strategizing and coordination, if you're the patent owner, know this argument is coming. Know that the other side is going to be looking at your portfolio and figuring out what is the earliest expiring patent, how do we use that to challenge, the patents in this case, and audit your portfolio. See what you can fix early before you're in the throes of the litigation needing to deal with it.
Bill, your thoughts on that?
I agree with Sherry on this.
You don't agree with me?
No.
Well, you had to be here.
What he's doing, I'll tell you what he's doing. You weren't here yesterday. He knew I wanted to take a picture of him, and so he gave a 2-word answer.
I got you.
Yeah.
Okay.
If Ayal is here, damn you, Ayal. Because he's the one who started that yesterday. So in any event, all right, so Cellect, you have to deal with it. Know it's coming. Be prepared. Don't be surprised. The next one on the list is how does a patent owner and a generic settle an ANDA case while minimizing antitrust risk in 2023? I mean, is it still a problem? I mean, I think what we talked about is that in any settlement, you're still going to want your antitrust experts to take a look at it, right?
Oh, I think that's right. Most of us that operate in the industry have a pretty good feel of what the DOJ, what's going to really raise concern for them. Mm-hmm. And so, we can look at it and say, look, we can go up to this particular line, but not cross that line, and we're not going to, raise any concern there. And so I think that, yes, you can engage antitrust lawyers on that, but, we settle cases all the time. I mean, I would say that a majority of these cases actually settle. And so, we're well versed in where that line is and how far we can go. And if you're on the generic side, you often want to take it
right to the
line if you can. Yeah,
because that's a payday for them potentially.
It can be.
Yeah.
It can be. I mean, it can be. I mean, it's important to try to protect yourself with most favored nation clauses, for instance, where you're coming back and saying, well, look, if somebody settles later than me, I want to get exactly what they got. Right. And it's your job to sit here and ensure that you draft something that gets you there, and also to try to get something extra that maybe somebody else can't get, and there's strategies.
And it's the little extra stuff that depending upon who's sitting in the White House and has appointed the folks in the antitrust division, that may or may not create the problem moving forward, right, Brianna?
Yeah, I think if you feel like you're being a little cute or a little too creative, that's when you really want to get your antitrust experts to look at the agreement. We've seen a lot of issues from side agreements that purport to be, not part of the ANDA settlement, but get looped in and get challenged. And you just want to make sure that you have folks, like Blake mentioned, we look at these agreements all the time. We're well versed in it as IP lawyers, but if you feel like you're being a little too creative or coming a little too close to the line.
Side agreement that would tend to worry me. I mean, It would seem like, well, if it's got to be on the side of the agreement, then why does it have to be on the side of the agreement?
What are you covering up?
What are you covering up? What are you trying to hide here? And Okay, so Phil, do you have any thoughts on this? I mean, how big of a risk do you think it is today?
Well, I think you can mitigate the risk of the government complaining. You have to file your copy of your settlement agreement and so on. And I think by now my impression is that people aren't paying generics to stay off the market. Maybe they're allowed to reimburse some attorney's fees. I think that's not a big deal, but more nuanced now and of more concern are third-party antitrust suits, of which there are a substantial number who are complaining simply about the nature of a settlement that doesn't allow the generic to introduce the generic product until sometime after some delay, whether you take this, what I would think of as the standard settlement, there's, say, 5 years left on the patent, and it's a case that could go either way, and the parties agreed that the generic can come on 2.5 years out. These third-party plaintiffs now, the private plaintiffs, who are the payers, who are paying for what they think is inflated prices for the drug, in the meantime are bringing class action suits against both the generic and the branded for having made the settlement. Then, the FTC isn't complaining about that, but it doesn't mean that you don't have to worry about it, and they're trying to construe terms that might seem innocuous between the two parties, and I haven't heard most favored nations, because that tends as being one of them, but things like authorized, whether the brand is going to introduce an authorized generic, and if so, how much notice will be given is a hot area for them to raise, because they're suggesting that it inhibits the introduction of an authorized generic in one way or another, and that itself may be part of an antitrust complaint. So you have to, I think I think you can handle the government more easily than you can handle these third-party plaintiffs.
Right.
And so you have to keep that in mind.
Yeah, well, we saw Baltimore trying to use the antitrust laws in the Northern District of Illinois to say that there was antitrust violation with, I think, Humira, right? Humira was involved in antitrust violation. So there's a lot of creative antitrust theories out there, maybe not so much at the moment on the part of the government, but and obviously the reason for, I shouldn't say obviously, probably everybody in this room understands why that is, but if there's an antitrust violation, that often comes with kickers and attorney's fees.
That's exactly the reason these cases are being brought, because the hope is treble damages and attorney's fees being awarded. And so when attorney's fees are a possibility, there is not the same motivation to wrap the case up in a hurry that there would be if attorney's fees weren't likely to be awarded. So I think it's something that the industry has to worry about.
Right, and that's why we see, I think, some creative theories, to be polite. All right, so now we're going to transition a little bit to pick up on some of the other stuff that we talked about yesterday, which was we spent some considerable time talking about Amgen, and we want to talk about Amgen and how that's being used for defensive purposes in Hatch-Waxman litigation. Blake, what's going on there? Have we started seeing Amgen rear its head in ANDA litigation?
I think you've always seen the premise behind Amgen rear its head in Hatch-Waxman litigations. It's always been the theory that, behind generics, that, you have to enable the full scope. And so it's not, to me, it's not a new position for generics to come forward and say, hey, we're gonna challenge these claims. I think now that the Amgen decision has been decided, it's, you're going to see it in more full force. And, 112 has has had a lot of play in the Hatch-Waxman world over the last 10 years, both from an enablement and a written description side of things. And as I was telling Gene earlier, it's a very viable defense from a generic side to play against an obviousness defense, because it kind of forces a patent owner, brand side, to walk a line. Am I going to say this is really unpredictable? And if I'm going to say this really unpredictable, then you might run afoul of enablement, or you might run into the possession standard of written description. Or if you're going to say, look, this is, a person born in a skill in the art, they wouldn't have a problem doing this. Then then you're saying, okay, well then that's in the prior art. And so I think you see in a lot of these cases, and more times than not, you see 112 positions and 103 positions, just for that simple reason, because you want to try to flesh out exactly which way are they going to go, because I want to know by the time I get to experts which one do I need to spend more time on, because this is generics file a bunch of cases. They need to know exactly where to put their money, what defenses to put their money behind. And so it kind of forces that through discovery for us to sit there and say, hey, look, we're gonna take this 112 position and move forward with it, a lot more earnestly than we are the obviousness, because of the positions they took at the contention stage, where, hey, they really wanted to argue that they're really concerned about this obviousness case, and they're really arguing unpredictability. They're walking right into a 112.
So, and that's another issue that I know is going to come up in the next panel when we talk about the PTAB. But how do you thread that line to make, and then is it a harder line to walk after Amgen, or has it always been this minefield to go through and try and get around 112 arguments without walking into an obviousness argument? Brianna?
And I think it's always been a minefield. It's something we've been taught, we always deal with in our cases. And it's most prevalent, as we talked about this morning, when you have parallel proceedings and you're making 103 arguments, say in front of the PTAB, and then you're forced to deal with those arguments when you have a 112 issue in your litigation. But threading the needle is exactly, what you have to do, and you have to try to advance both balls at the same time. As Blake mentioned, you might realize that, your 112 case is a little better than your 103 case, so you're going to put the weight behind your 103 argument and maybe take a little bit more of a risk on the 112. But I think, to our earlier theme of coordination, you also want to make sure your litigation team is focused on both of these issues, and that you're not advancing one part of your team is working on one issue while the other part of your team is working on another. You want to make sure it's all coordinated. And you also want to try to be mindful of these things when you're prosecuting the patents. How can you fix it before it becomes a problem? Is there more data that you can include to support your 112 case so that you don't have to make those arguments down the road?
So it does seem to me that this is, and I understand that 112 has been around and gets used all the time. It seems like it's going to become, to me, a much more difficult line to walk after Amgen, simply because the way that the defendants will use this is to say, well, look, here's what Amgen did, and the Supreme Court said that wasn't enough. So now it seems like, particularly for the legacy patents, which are the ones that will be being litigated for the next at least probably 5 years or more, you're going to be dealing with things written not with an eye towards Amgen. And in order to overcome that, it would seem like you would need to make more of an unpredictability argument. And then, am I missing something, or is this going to really be potentially most problematic over the next, say, 5 or 6 years? Phil?
This has been around for a long time.
Yeah.
I mean, the issue, first of all, you have to have a genus claim that needs to be asserted in order for the issue to come up. If you have, in the small molecule area, you should have a claim that's a picture claim on your own compound, and since that has to be matched, you ought to be able to, steer clear of the 112 issues to a great extent. Now, and then just fight a regular obviousness case on the compound. So it's a bigger thing in biosimilars because you never have exactly the same compound. You have your sequence listing for your biologic, but the biosimilar is not going to have the identical sequence listing. So you're in a different area. But these issues, to me, are less attractive at the trial level than they are at the appellate level, especially if you have a jury involved. If you think back, there was a reversed $1.6 billion verdict against AbbVie, on that had been tried, I believe, in Texas, and that had a big written description enablement defense, and the jury found on the facts in favor of the plaintiff. But when it got up to the Federal Circuit, they decided, well, there were a large number of alternatives, and they weren't satisfied with the written description and enablement outcome. The same thing happened in a case, a Cordis case against Boston Scientific, where for drug-eluting stents, where the drug on the stents was rapamycin, and they had a definition of what a rapamycin was, and the accused product had rapamycin is a fairly large molecule, and they had hydroxylated the molecule in order to make it more soluble, but otherwise it hadn't affected its effect, which was as an anti-inflammatory, basically. But by the time it got to the Federal Circuit, after winning below, by the time it got to the Federal Circuit, they said, well, if there can be 10,000 substitutions at this end of the molecule, and they haven't enabled this class enough, and the Federal Circuit seems to have a real problem with numbers, high numbers.
They do, and maybe I'd like to ask you that. I mean, what do you do as if you're representing the patent owner when you know that the Federal Circuit doesn't like big numbers, and it seems to me that a lot of this 112 and certainly obviousness, once KSR gets enacted, thrust upon us is probably the best way to say it. Once KSR gets decided, it almost seems like an invitation to apply hindsight. And I know that they say, oh, we guard against and everything. Well, I'm not seeing an awful lot of guardrails against hindsight after KSR. And it looks to me like in the enablement and written description area, there's a lot of Monday morning quarterbacking and saying, oh, well, we know that this was state-of-the-art the way that you would file this application when you did it. But now armed with 10 years more information, 10 years more science, and a desire to get patents to be more narrow, we think you should have done something different. And it strikes me as just, I shouldn't characterize it. I'll characterize it later maybe. I want to get your thoughts.
I mean, most claim terms have a degree of whatever you want to call it, ambiguity or breadth. Mm-hmm. If you claim a stainless steel member, if you claim a steel member, there could be 100 steel alloys that could be used in that, and maybe even you could argue thousands of steel alloys that could be used for that steel member, and we never have a concern about that.
Right.
And in the antibody area, we know you can make conservative substitutions, and a large number of them, and not affect the function of the antibody. But on the one hand, the Federal Circuit is fairly hostile to that. And the effect of it is to discourage the development of certain biologics, because you're looking at what kind of exclusivity am I going to get, and fortunately there are regulatory and other incentives we've talked about that continue to have them be developed. But in terms of your patent protection, it's very difficult to think you're going to have solid patent protection against the biosimilar. I think it's much harder in other arts.
Blake, or go ahead, Brianna.
No, I was just going to say, I think another practical impact of the Amgen case and all of these issues is I think we're going to see an uptick in dispositive motion practice. I think we're going to see more summary judgment motions filed early on in the case, in the Hatch-Waxman cases, trying to resolve them earlier on these 112 issues.
Yeah.
And if it's a jury trial, trying to, for the reasons Phil mentioned, prevent the issues from getting to the jury.
So now, Hatch-Waxman litigation is clustered, though, right? I mean, a lot of it happens in New Jersey, right?
Well, and that's what I was about to say. So a majority of the Hatch-Waxman cases happen in Delaware and New Jersey. And you're dealing with judges in both of those districts that have a lot of these cases. And they know the law. They see it, I'm not exaggerating, hundreds of times a year in these cases, just over and over and over again. And so you're not dealing with judges that are like, enablement, I've never heard that concept.
Right.
Or I remember going into court 10 years ago, and we went in on the third day and said, or the second day after, and we said, oh, we're settling the case, and the judge looked at us and said, I was looking so forward to hearing about the enablement requirement. And it's like, okay, well, you didn't know that right now, then we were in trouble, because I was on the generic side of things at that point. So my point is, these judges know written description, they know enablement. And I come back to this decision that I was just talking about Judge Andrews in this Allergan v. Sun case, because most of that decision is on written description. And if you read it, if anybody likes reading Judge Andrews' opinions, they're all often very witty and very straightforward. And these judges get it. They get enablement. They get written description. And as I told you before, I think sometimes they latch on to those arguments quicker than they do an obviousness argument, because they're not looking at prior art and trying to match up elements and saying, oh my God, this is highly scientific. If we're looking at written description, if we're looking at the four corners of the patent, is it there or is it not? A lot of times then they're looking at it and saying, well, that's pretty straightforward to me. This expert was pretty compelling on that issue. On an enablement side of things, an expert can carry a lot of weight saying, look, they wouldn't know how to make and use this thing. They've claimed too much. And it comes back from, if you're looking at it from a biosimilar side, you're sitting there saying, claim what you invented. Don't try to claim more. Claim what you invented. And if you claim more, then we're going to come back and say, you tried to claim more, this patent's invalid. And that's the way that biosimilars and generics have looked at enablement for years. And now, as I said earlier, Amgen just kind of emboldens generics more to kind of take that position and say, look, you're going after too much.
Yeah. No, and if Amgen winds up being sort of like the stamp, like the hammer to drive home, claim what you've invented, then I think we'll be fine. And then it really probably doesn't change anything, and maybe actually it gets us back to where we should have been all along. I just wonder, and I'd like to get all of your thoughts on this. What is the risk that Amgen becomes more than what you think it could become right now? And the analog is, when I read the Alice decision, I knew right away that it was catastrophe. And I had all kinds of people saying, no, you're wrong, you're overblowing it, the sky's not falling. And when you go back and you reread Alice, it's not that bad. The decision's not that bad. What the problem was is how it was going to get misused predictably at the patent office by district courts, because unlike in the ANDA case where the cases are clustered, patent litigation, it's still clustered in spots, but it can happen anywhere. And you do get the judge who didn't really want the case or didn't want the patent case, and you offer them an opportunity to get out on a motion to dismiss, and they take it. And then there are just philosophically some judges who do a lot of patent work that think that was what the Supreme Court wanted, and I can't say that they're wrong. So they do take the opportunity to get rid of these cases earlier. And I wouldn't do that if I were a judge, but I can't criticize that. I mean, that's within the envelope of reasonableness. So what is the risk that Amgen becomes that all-powerful, almighty hammer, Thor's hammer against patent owners. Phil.
Well, what you're going to see is that biologics will be developed then based on the availability of regulatory exclusivity in that period of time, and patents will become far less important in
Right.
that area, because viewed by the innovators of the original biologic, these conservative substitutions would be akin to, I've patented a blue car, I'm selling a blue car, but someone else who wants to sell a red car that's otherwise identical can do that. What kind of patent protection is that?
Right, no, it's not. And so, but the thing that I do worry about, and I get the regulatory exclusivity and sort of a different path to exclusivity from a patent. But in the IRA scenario, they're already talking about pushing down the number of years in which the price fixing will apply. And I just worry about that kind of, we're seeing an awful lot of jerry-rigging of the patent system and exclusivity rights in a way that we have historically seen year after year with the tax laws, and that leads us to tax laws that aren't particularly principled. They're just, you pay because of this, or you get a deduction because of that, and they're cobbled together, and I feel like we're going in that direction.
But, we talked a lot about that yesterday, but what we didn't talk about were some of the perverse results. Orphan drugs, as I understand it, are exempted from that law. Mm-hmm. But second indications will bring it back in. So now you have small startups or the equivalent who may be focusing on developing orphan drugs with no intention of crossing the line, where they will end up, doing any research on additional indications. And so you'll end up with an orphan drug. And by the way, you talk about saving money. Right now, orphan drugs are often reimbursed, depending on the size of the patient population, at $500,000 per patient per year.
Right. No, and I get it. I'm sighing because with innovation, you never, by definition, it's new, and you don't know where it's going to go, right? So if your second indication of an orphan drug kicks you into the IRA, what is that going to do to innovation? You don't know what you're looking for, or you don't know what you know what you're looking for, but you don't know what you're going to find until you find it. And oftentimes it's not, how many times throughout history, not just in life science here, how many times throughout history, the thing you were looking for in trying to accomplish was a complete and abysmal failure, but along the way, you found something remarkable, right? The microwave oven was a mistake. The guy had a chocolate bar in his pocket and it melted, and he had to figure out what happened. And now we have a microwave. And everybody in the country has got at least one, right? Many people have more than one. So I just worry about that. But I see Charlie's up here with a question. Charlie, do you want to go ahead?
Yeah, I was going to follow up on the notion of predictability in Delaware and New Jersey and so on. Given the aftermath of TC Heartland, I don't know. It isn't necessarily a safe assumption that that's always the case. For instance, Biogen was one of the institutional cases we sort of talked about yesterday that came out of West Virginia, given that Mylan,
right,
was only venued there. So, curious how that impacts your sense of Amgen in particular.
Yeah, I still think that based off the venue and jurisdictional case law, there are a few. Mylan typically wants to take their cases to West Virginia. If you look at their record in West Virginia, I don't think it's been necessarily any better than in Delaware and New Jersey. I still see a majority of the cases that are filed in this business in the Delaware and New Jersey, and I just continue to, because they're all incorporated there. It's easy to get them in Delaware. And from New Jersey, if you go anywhere in New Jersey, you'll run into a pharmaceutical company, whether it's a generic or a brand company. And so those two jurisdictions, I don't see it leaving those two jurisdictions anytime soon.
And that's proven up in the stats too. Just
Yeah.
if you take a look at the statistics, New Jersey and Delaware account for 90 to 93% of
Yeah.
all ANDA
So-
cases.
Right, that's clearly the case now. I just, the question is what happens
Whereas-
if, and I think it's smart. I know one instance, for instance, when ANDA company gamed the system and was able to get sued in the ED Virginia, rocket docket
Right.
for that exact reason.
So why does Mylan like West Virginia? I mean, and I like West Virginia; it's beautiful. But why is Mylan going to West Virginia?
I don't know specifically. I don't represent them. I've never taken them a case in West Virginia. I have a feeling because it's hometown, and that's why.
So they think that gives them the advantage, and that's.
I think that's right. I think that's their belief. I'm not sure it's panned out
So let
that
me
way.
ask you: does hometown advantage matter as much as it used to in today's world?
From a bench perspective, I don't think it matters.
Yeah, I would agree with you that I don't think that the outcomes are materially different. They may believe that they have a procedural advantage because the case is decoupled. And whether that's an advantage or disadvantage will depend on the particular case. But I believe the judiciary in West Virginia has done a fine job.
Yeah.
Yeah, I would say I think for the most part, hometown doesn't matter, but in some jurisdictions it does. I mean, you wind up in some places it really matters that
Right.
who's standing at counsel table knows the judge or, is a known entity. And obviously you can hire local counsel and you make sure that local counsel is very involved throughout the proceeding. But it's definitely something we talk to our clients about when we're evaluating where to file.
Yeah, the judiciary can take an entirely different approach. I, many years ago, had a case that ended up in New Orleans. And in our first status conference, the judge basically said, well, this case is never going to get to trial. And we looked at him, both sides looked at him. He said, well, we have a lot of maritime cases here. We're very busy, and we aren't that experienced in patent cases. And this, I just don't see this getting to trial. We may get reassigned if we get a new judge, but basically he was saying, I'd advise you gentlemen to go settle.
Yeah.
In those days, it was gentlemen, but today it would be different.
Yeah.
They've opened the doors.
Okay, so we got about a little over 10 minutes left, and the one question I want to make sure that we get to, because I want to hear what you have to say, and I'm going to ask a similar question to the next panel on the PTAB, and then we're going to compare and contrast and see whether the litigators and the PTAB lawyers have the same answer, is should you file a PTAB petition before a paragraph 4 certification window opens?
I'm going to say it's very case and strategy dependent. There are a number of
That's
factors.
a chicken answer. That's the lawyer. It depends.
I think if you're the first filer, you want to be thinking about what's the estoppel risk here, what are my arguments, right? That's the biggest thing. Getting ahead of the litigation, filing the IPR before the litigation's even been filed, you have a timing advantage. You can possibly, get rid of issues before you have to dump all of the money into defending the case. But you're signing yourself up for, what invalidity arguments you're going to present in the district court if you don't prevail at the PTAB. If you're the second filer, you can just wait out the first filer's exclusivity. You can see how the invalidity arguments have played out in the first filer's case. Might have more of an advantage to filing an IPR.
So that was the second part of the question is what do second filers do? Blake, what do you think?
Well, I know you're saying it's a chicken answer, but it is true because if you
no,
look
I
at,
know
No,
it is.
but
Of course.
if you look at these cases, you're going to have to determine if you have a good non-infringement argument, you're likely not going to want to go to the PTAB because you want to get on before everybody else and you want that patent to stay in place. And you want to block them. Now, if you're a second filer and you think that a first filer has parked their exclusivity way, way, way out, and it might be advantageous for you to take something to the PTAB and try to get that invalidated, to try to trigger try to trigger a forfeiture. I mean, you know, Hatch-Waxman lawyers love to talk about forfeitures all the time. I mean, it's one of those geeky things that we talk about a lot. It doesn't happen that often, but it's one of those things that, you know, people talk about, like, hey, look, it looks like the first filer has parked this out, way out 5-10 years from now. Is it something I can do to try to trigger that exclusivity where I can get on the market sooner? And that might be instances where you say, hey, look, I'm gonna take this to the PTAB and see if I can get it squared away there.
Wipe it out. So now the question, and maybe Phil, this is one for you because you were there when this was all created in the on behalf of 21C, and you were still at Johnson & Johnson at the time. So I know that you had conversations, you testified on the Hill about the AIA and all that sort of thing. There was not this belief that in the life sciences area, people were going to use the PTAB. And that has caught some by surprise since. But I still don't necessarily understand why anybody is using the PTAB. I mean, if you're a generic, you want some level of exclusivity, right? I mean, you don't want to, like, I don't want to fight to open it up for the whole market. You lose your patent, then I can get in, but then everybody can get in. I mean, I don't get the business angle here. What's really the dynamic that's going on from your perspective?
The feeling during the development of the AIA was indeed that generics would continue to favor the Hatch-Waxman regime, the structure. But it was not anticipated that as many IPRs would be instituted as a percentage, or that the PTAB would be as friendly to the challenges as they've turned out to be. But the other thing was, at that time, I believe it was close to the time of the passage of the Medicare Modernization Act that changed the first filing status from a single first filer to everyone who filed on NCE1 on the first day that they could. And that changed the nature of the generic industry markedly, because if you had 5 or 10 filers on the same day, no one essentially was going to get 180-day exclusivity. And back in the day, my understanding was a huge percentage of the profit that came from introducing a generic came in the first 180 days. So, you know, that changed the dynamic a great deal, and perhaps made it less bad, if you will, if you went and invalidated the PTAB, because you weren't really getting 180-day exclusivity anyway.
Right.
But remember, the PTAB decision, because it's an agency decision, doesn't automatically put you on the market if you're a generic. You still have to go through the appeal in order for it to become final. And in the meantime, if you have a Hatch-Waxman case going along, the Hatch-Waxman case may finish, and you could get your regulatory approval beforehand.
So you say, like, it's got to go through the appeal, as if the Federal Circuit actually exercises some level of review over the PTAB. The only time that I see review exercised by the Federal Circuit over the PTAB is when the patent owner has prevailed. And I won't name names, but I know others in the industry have kind of anecdotally noticed that as well, that the PTAB does not seem to get overruled when the PTAB invalidates. The PTAB only ever seems to get overruled when they have affirmed the patent.
But from the standpoint of getting a regulatory approval, that patent technically still exists until the Federal Circuit renders its decision.
Okay.
So that even though it's not because, I mean, it's possible it's reversed, but even if it's not reversed,
it's still actively challenged.
The generic is not allowed to introduce its generic product until the patent is finally gone. And,
okay.
And in the meantime, depending on when the IPR petition was filed, you have what is essentially a 30-month clock running when the district court is trying to get to a decision. And that decision is the one that you want to get if you're the generic and you're going to win the litigation.
Okay. All right, so we are down to the last 4 minutes. So this is the 4-minute drill here. For football fans, we'll get that. So in your last 4 minutes here, panel, what I'd like to ask you to do is give us your parting thoughts. What thing do you want the audience to take away, remembering in particular about the state of ANDA litigation, where we're at, where we're going, anything really? What's your one thing? And if you cheat and include two, I'm not going to slap you with a ruler like Sister Mary might have. But what is your parting thoughts? Phil, let's start with you. Then I'll go to Blake, and we'll give Brianna the final word.
Well, you're asking me to summarize all of the things that we've
all
come
the
up
brilliant
with.
things that you've said.
I know
that there can't be just one.
If it's
that
all the
is
brilliant
like,
things I said, we're done.
Well, I can't. There can't be only one brilliant thing that Philly
Well,
said.
look, we've talked about it throughout the conference. I mean,
Yeah.
we have to fix patent eligibility. We have to address the PTAB and improve the due process that's available to people who are patent owners, and in fact, provide better due process for everyone, one way or another, either at the PTAB or through the appellate process. We have to have people coming away from the use of our system feeling they had a fair day in court, regardless of which side of the controversy they were on. And
Right.
I don't think we have that. And beyond that, I do think we have to address some of these issues about, written description and enablement. We have to. It should not be, in my view, different for different art areas. There should be a simple understanding as to what you have to do and what you don't have to do, whether you're claiming a stainless steel member or an antibody.
Right.
So, and I could go on.
No, I know, but those are two good things, and we need to follow up on those. But I think that shockingly, the lack of due process, if it's most apparent anywhere, it seems to me to be at the federal circuit. And that will require a lot more explanation probably. But you get where I'm going when you say that they only seem to overturn the PTAB when the patent owner has won. And there's not a lot of certainty. Well, I shouldn't say that. Once you walk in and you see the judges who line up and sit down at their chairs, now you know what's going to happen to your case. But that's not exactly due process, and it's not exactly certainty. But we'll follow that thread more for sure. Thanks, Phil. Blake, your final thought here.
Sure. I mean, I think what we've talked about today from a Hatch-Waxman standpoint is that, if you're looking at it from a generic side of things, make sure you're, looking at the file histories, looking at the patents in a way that you can assert the defenses, the 112 defenses, the obviousness defenses early and as strongly as you can early, because a lot of times you can set yourself up for a settlement agreement early that might save your client some money early on, and because of the defenses that you have put forward, the brand say, hey, we're not going to go through with this, we're going to give you a little bit extra time, we might give you a little bit something extra that we might not give somebody else. On the biosimilar front, I think it is so important to understand that if you don't get started early in understanding what you could be facing, then you might have spent a lot of money, you likely have spent a lot of money on something that you may be well behind everybody else in launching, because you don't understand exactly what patents you're facing, what those expirations are. And if you understand it early, you might understand that, hey, I might have been able to get on 3 years earlier than I would have if I would have used, this formulation, or if I would have used this process. So it's such a different game than Hatch-Waxman, because you need to understand early in the game what you're facing.
Great advice. Thanks for being here, Blake.
Yeah.
And the final word goes to you, Brianna.
Yeah, I'll take the other side of the coin from Blake on the patent owner side. You know when your regulatory exclusivity is expiring, avoid surprises. Make sure your house is in order. Make sure all of your teams, as we've talked about, all morning, are aligned, and make sure that your regulatory position, your prosecution position, and your litigation position are all working together. We know these challenges are coming. You know what the defendants are going to be arguing now coming out of, all of these developments. Make sure you're putting yourself in the best position well in advance.
Great, excellent. Thank you very much, panel. I appreciate it.